Hi, my name is Ken Walsleben. I'm a professor of entrepreneurial practice at the Whitman School of Management at Syracuse University. And I would like to share with you in this video some essential legal knowledge that you need to know in order to be successful. And you might think, for example, that you already know most of this. It's really not all that critical, but let me tell you, this is indeed quite critical. And I assure you there are things that we will cover that are indeed new to you and will help you be more successful in the long run with regard to your business proposition. What I want to do is clarify for you what I mean by essential legal knowledge. And in particular, the introduction of myself will be part of our objective, as well as what we'll need to have you know about purchase orders, order fulfillment, invoices, and collateral. Now, you might think you know most of this stuff, but I think the time we spend here in the next little while should prove instrumental to your successful performance under future contracts. So by way of introduction, prior to becoming a full-time professor a decade ago, I built and ran a finance company for 20 plus years. We specialized in invoice factoring, which is something we'll discuss in more detail on another of these videos entitled, "So the Bank Said No, Now What?" But let me tell you why that's applicable in terms of experience. You see, during that period, I helped finance invoices for approximately 1,000 different small and mid-sized growing businesses. These were firms that in many cases sold their goods or service to big box stores. And as a consequence, we had a working knowledge of what the law had to say with regard to how that business was transacted. But what I want to be sure of is that we understand the roles that we played. For example, I want to start with a bit of a disclaimer. I'm not an attorney, but I was a legal practitioner in this space for over those 20 years. So I kind of know from having worked with attorneys and having to litigate in some cases, I kind of know how this game is played. I know what the law says. So while I'm not giving you specific legal advice, I am giving you critical background knowledge. Now, let me also clarify that I'm preparing this video to enable veteran entrepreneurs to be more prepared to conduct business with big box retailers. And the phrase big box retailers can prove kind of cumbersome. So let me also say under this disclaimer section that rather than continually refer to big box retailers, I might sometimes substitute real world company names, whether it be Walmart or Home Depot or Target or Walgreens or Lowe's or whomever. Please understand that I'm doing that just for illustration purposes. I'm not specifically citing those particular companies or their business practices unless I make that specific reference to them in this conversation. So please understand those firms. I'm using those names for simplicity and conversation, not specificity. And it's just a way to get around to having to continually say big box retailers. So let's roll up our sleeves. Let's get real. Let's first talk about purchase orders. And you should understand that purchase orders, indeed most everything we discussed today, is going to be covered by the Uniform Commercial Code. It's also referred to and abbreviated as the UCC. This is the body of law. If you want to really truly dig into some of the legal issues we talk about, or to sound like you're really more on top of things when you do speak to an attorney, please know that the Uniform Commercial Code is what governs this. And while the entire Uniform Commercial Code covers all sorts of commercial commerce, a lot of times we'll be referring to specifically to Article 9 of that Uniform Commercial Code. Now, this is essentially the big body of law. Now, it's not criminal law. That's an entire different body of law, nor is it bankruptcy law, which is another body of law. But as it relates to commercial transactions and the conduct of commerce in the business world, Uniform Commercial Code is really where it's at. Now, with regard to purchase orders, let's get started here. You've got great news. After weeks or even months of dancing with your buyer at a big box store like Walmart, they've finally issued you the purchase order that you've been waiting for. And it comes in digitally or in the mail. and it says purchase order on it, and it's lots of pages. The first page talks about all the wonderful product that they're going to buy from you. They're going to buy 20,000 units of your product. And then it's followed by half a dozen or 8 or maybe 10 pages of legalese, boilerplate, little small font language that talks about all sorts of different things. Everything from types of transactions to co-branding to instructions for distribution centers and everything else. And after the initial euphoria of saying, hey, we finally got this order. This is great. We've been working to sell this order. It's for 6 figures. There's 20,000 units of our product. You stop and you realize, hey, I've got a lot to think about here because there's a lot of other pages here. What's it all mean? So let's understand the law of the land, that UCC code. And let's understand that purchase orders themselves are legally binding upon the issuer. So when it was Walmart or Home Depot or whomever else issues you this big, wonderful purchase order, please understand they're saying that based on these terms that are embedded in this document, we agree that we will pay you upon your performance of it. So make no mistake, this isn't just a gee whiz, we might consider working with you kind of thing. This is saying we are committed to work with you under these terms and we will pay you accordingly. Now, understand as well that once you sign it, you're legally accepting those terms and conditions. So those additional pages 2 through 10 are pretty important because they're all referenced. You might love that first page where it talks about what you're sending, but please understand that once you accept this, you're saying, I'm good with all the terms and conditions that are referenced there, Mr. Buyer. Now, that means that you shouldn't just blindly sign away. You might also need to know that those terms and conditions spell out the entirety of the proposed transaction in the eyes of that issuer, of that purchaser. So they're saying, hey guys, this is everything. And it probably in there says that, they won't defer to a court. They want to have, binding arbitration. If there's a dispute, they'll reserve where the dispute's going to be held or heard, on what terms and conditions, perhaps by whom. It's going to spell out what they're willing to pay, how they're willing to pay. It might specifically disclaim any late payment fees or anything of that nature. So please understand that when you're signing for the whole deal. And you also need to understand that once this is executed, this purchase order comprises chattel. Now, chattel is a specific legal term that you need to understand more about. So you hear this word chattel and you say, huh? Okay, fine. Why do I care? Well, chattel is a document like a purchase order that binds the two parties. It can be a purchase order. It can be an invoice. It can be anything that once it achieves chattel, it is legally enforceable and legally transferable. You see, chattel can become an asset of your business. That piece of paper that you might think of as a promise to eventually deliver, that has value now that both sides have signed it. And it has the ability to be pledged as security. So if, for example, you're working with a lender or want to work with a lender, it can be pledged as collateral. All right. So it's because it's an asset of the company. If you already have a loan, it might already be encumbered by the collateral pledge of that loan. Or if you need to find additional funding, as we talk about in that other video entitled, When the Bank Says No, What Do You Do? Well, in that scenario, you might now have an asset that you can pledge to a new financier to help you find the funding to be able to perform under this big, beautiful purchase order. So please understand that this piece of paper that you might have considered to be just kind of a promise has some legal status. It has some shoulders to it. You can even assign that document to another party to help you perform upon it. Because if the order is super big and you need a partner, they might want to know that they've got some legal standing when they step up and start writing checks and incurring costs to perform with you. And you can, to satisfy their needs, assign them an interest in this chattel. So now you start to realize, hey, this paper's got some value to me. And you can even buy and sell this piece of paper. It literally can be sold. Now, you might also find that a savvy purchase order issuer, like a big box store, well, this ain't their first rodeo. So they know that you might need to pledge it. They know that you might want to assign it. They know that you might choose to sell it. They might have provisions in that little legalese that follows that big, beautiful first page that might prevent you from doing one or more of these things. They may prohibit you from doing one or more of these things. So please understand that when we talk about chattel here, I'm talking about it in general, and certainly it has these wonderful characteristics, but now you need to go back to that original purchase order and find out if any of these characteristics are restricted. All right, they might allow you to pledge it, but they may not allow you to sell it. They may not allow you to assign it without permission. So if you're going to work with another party to perform on this order, if you don't have 20,000 units laying around in inventory, if you need to find some additional funding, these are things that are important to be aware of. Now, let's also talk more about what some of that fine print in that purchase order is likely to cover. Make no mistake, that purchase order issuer didn't put those 8 or 10 pages together for just mere excitement and to try and show you how smart they are. Those pages matter. For example, it might not infer a true sale. Now, you as a working practitioner may not appreciate this until, unfortunately, it might be too late. But what you want to have when you sell this product to them or this service is you want to know that this is a true sale, meaning that upon your performance, your work is done and you can expect payment. Now that's what a true sale is, and that's what you're shooting for. And we hope that that's what they've provided you. But it's also possible that your purchase order might consider the arrangement of a conditional sale, meaning that the obligation of the issuer to make payment is conditioned upon certain things beyond just what your performance is on pages 2 through 10. It might be conditioned upon the issuer's ability to sell the product to the general consumer, the general public. Wait a minute, you think, well, isn't that their job? Don't they take that risk? You might be thinking, wait a minute, I've sent them my 20,000 widgets, game over. They need to pay me. Well, when you read that purchase order language, you might find that it's not that clear cut. In fact, you might find that their requirement to pay you is going to be conditioned on their ability to sell the goods to someone else. What's that mean? Well, that means that if you don't have a true sale, if you've got a conditional sale, you might someday get inventory back and a smaller check than you're anticipating. Let's understand what that might mean. You might find in your language that the transaction is construed to be a consignment sale. If that's the case, let's be sure we understand what that means before you sign it. You see, a consignment sale says that they are taking custody of your goods or services, and they are going to resell it to the consumer, and they don't owe you payment unless they are able to sell it on to the consumer. Now, in a consignment sale, it's normally the case that the issuer, let's call it Walmart in this case, the issuer is taking on responsibility for the care and custody of the inventory in the store. So if something is lost or stolen, that's on them. But if they can find the goods or a product to return to you, that means that at some future date, if it hasn't been sold, guess what? There's a big box worth of product coming back to you, and the payment that you're receiving is going to be considerably smaller than you anticipated. Bad news if you've got a consignment sale. If you think that's bad, I can make it worse. What if it's a pay on scan transaction? If you see this phrase, please be alarmed. Please dig into it. What this means is that the seller, or I should say the seller of the goods, which is to the general public, going back to our example, let's instead of me saying big box retailer, let me use Home Depot in this case. Let's say Home Depot has issued a PO to you that says it's pay on scan. What that means is Home Depot doesn't owe you any payment until such time as they sell the goods. You don't have any expectation of payment until the month following their sale of the actual goods. And to make it worse, a pay on scan transaction does not incur, how do I want to say this? You are still at risk for theft or damage of the goods. Wait a minute, you say, isn't it, it's at Home Depot, it's not under my custody and control. Doesn't matter. If the goods disappear, oh well, all they're obligated to do is return to you the inventory they have and to pay you for that stuff that actually was scanned through their sale system. So you see this language? Big alarms should be screaming out at you to pay attention because you don't want to blindly sign this. Now, you might also see language in there talking about allowances. What's that, you might wonder? Allowances are allowances for returns. You see, the big box stores, they've got a lot of customers and they've got a lot of stores and a lot of store managers. And those store managers are empowered to decide whether or not to accept a return of goods from the general consumer. So John Q. Public walks back into their store at Target and they return the goods that they purchased. Most retailers will accept the return because they don't want to get into an arm wrestle or a fight with the consumer. After all, the consumer is where their bread is buttered. So they'll accept the goods. Did you know that when they accept the goods back, that's a final decision? Because the purchase order may allow for allowances. And what that's saying is you give them a certain percentage of the overall sale of goods to be able to receive back from the general consumer and to return it to you, or not even to return it, to just dispose of it. So you think you're going to get paid on 100% of the sale, but if there's an allowance in there for 10%, you're not going to get 100% of sale. You're going to get 90% because they've allowed for returns of goods. Now, they can't get, as a matter of practice, the big box retailer can't run through and get your permission before accepting goods from their consumer. So they're going to make the decision whether or not to accept a return. And you live with that decision. That's what an allowance is. You might also find language in there talking about co-branding or co-marketing or some similar euphemism for the same. What's this mean? This means that the retailer, your customer, is going to market your product to their consumer base. They might put it in a flyer. They might put it online on their online sales sheet. They might have an in-store display. They might have a end cap at the end of an aisle to kind of further highlight your product. And when they do that, they're not doing that for free. You are joining them with the cost to do so. They will typically split that 50-50 with you. And you will find out that you've not only sold them the goods or service, but you've also incurred their cost of marketing your goods. When you see co-branding or co-marketing, pay attention. Let's find out what that means, because that's going to impact your margins substantially. You might find that the retailer might need to mark down your goods in order to sell them. You might have had a suggested price to the consumer of $10 per unit, and if it's not fully selling through or selling as quickly as the retailer wants it to, they will mark it down. Well, guess what? They're not interested in having the full cost of that markdown come out of their pocket. If they can lay that on you, that's how they make money. After all, the big box retailers have a reputation for being low price, not just because their margins are thin, but they work you as well. So if there's markdowns on your product, you might find that you are incurring the cost differential of that markdown. And finally, you might find that unsold inventory is coming back to you. Now, remember at the top of this page, we talked about true sale. Well, you might have thought you had a true sale right up until a big box shows up on your loading dock that says, hey, this is coming back from your big box retailer, and we're adjusting our payment to you accordingly. Do they have the right to do that? Is it embedded in the purchase order that you blindly sign? Let's pay attention, guys. And sometimes when you think it's a true sale, when the purchase order says it's a true sale, big box retailers have a nasty habit of returning unsold inventory to you anyway. And they dare you, essentially, to say something about it because you know that it will threaten your relationship with them. The buyers know this. They know that you want to sell them more goods or services. And if you kick up a fuss and say, no, 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 I don't want this inventory back, that's on you, you might be worried that they may not buy from you again. Well, that is a decision you'll need to make. as a business person. But ultimately, you need to know how that game gets played. Now, we've covered a lot of purchase order language and contractual agreement. Let's talk now about what's likely in all that fine print. And let me explain to you what's important to you. And I base this on personal experience. With regard to order fulfillment, don't be late. Do you realize that in your purchase order, it's going to say that you have to perform by X date? Let's say that's 30 days away. If your product shows up 31 days, do you realize that that purchase order is null and void? They literally do not have an obligation to fulfill that order. They can simply say to you, you know what? You missed the delivery date. You missed our window. It's a seasonal product. Sorry, it's coming all back to you. We're washing our hands of it. We owe you nothing. And now you're going to get those 20,000 units back, and you have a problem, a big problem on your hands. So if you're going to be late, be sure that you advise your buyer. Don't just hide and think, well, they won't mind for a day or two or a week. Trust me, this is their game. They know how to play it. You're new to the party. You can't be late and think that it's going to just work out. You have to advise them of your order scheduling if you're not going to be able to make their target date. You also will be instructed, undoubtedly, to deliver your product to different parties, different distribution centers of theirs. Walmart, for example, doesn't have a single distribution center based in Bentonville, Arkansas. They've got distribution centers all over the country because that's how they're able to fulfill their and quick delivery to all of their various retail locations. So they have distribution centers that they're going to instruct you. They're going to say, send 500 units to this distribution center and 300 units to that one, et cetera. You have to be sure that you follow that language and those instructions to the T. You do not want to simply send a big box of 20,000 units to one of the distribution centers and wash your hands of it and think, we're done. No, no, no. And if you don't follow their instructions, guess what? They can either they can decline acceptance of the goods, they can return them, or they can choose to ding you with fees and charges. What do you think that's going to do to your margin? They'll also tell you how to label the boxes. And to be fair to the distribution centers, you can imagine they're pretty busy places. When they get your delivery in on the truck, they can't be opening the box and trying to figure out what's in it and what was intended and who shipped it and all the rest of that. They have very specific labeling instructions so that when the receiving people on the dock see your box, they know exactly where to place it and how to distribute it. So follow that to the T. You need to track deliveries. You need to be able to confirm when that order is going to arrive. You need to be able to confirm that that order did arrive and that it was accepted. So you need to retain proof of delivery and acceptance at that loading dock. Don't leave it to the winds of fate for somebody to eventually at your customer to say, you know what, that was late. It didn't arrive here on time. If you can't prove otherwise, you're in trouble. So you need to obtain proof of delivery and acceptance for each one of those different distribution centers that you deliver to. They'll also instruct you to ensure that your product is sale ready, meaning that it's packaged for retail sale. After all, these distribution centers aren't receiving raw product and then repackaging it and putting barcodes and everything else on it. No, that's for you to do. That's part of what those instructions in the purchase order are going to cover. You need to be sure that your product is sale ready so that the distribution center can send it out to the retail location. The retail location can hang it on the shelf and walk away. It's ready to go. It's barcoded so that everything scans in their system and there isn't a crisis at the checkout counter that everybody's rolling through. Make sure that you follow their instructions. With regard to your shipping of the goods, let me educate you on something between the difference between shipping companies and shipping brokers. As the name implies, a shipping broker is not necessarily your shipper. They will engage and hire shipping companies to do so, and they will act as an intermediary. Much like an insurance broker works with independent insurance companies, so too do shipping brokers work with various different shippers or logistics companies. Please understand the difference. If you work with a shipping broker, you might get a better price, but you do lose some control of what's going on. You don't get to choose who the eventual shipper is. nor do you have direct contact with that eventual shipper. And if you're worried about delivery and timely delivery, you don't have necessarily as much control and vision as to what's going on when doing so. The worst part about shipping brokers, and I'm not looking to throw all sorts of shade on shipping brokers, but I do need to share with you that they can blow up, they dry up and they can blow away very quickly. I've seen shipping brokers rather, go from being normal and operating fine to being out of business inside of 30 days. So if you have the choice, I recommend, just from personal experience, to work directly with the shipping company who's going to handle your delivery. You are their customer. They want to see you happy, and they will provide you direct visibility as to where the status is of your given order. So let's put purchase orders aside. You've got plenty of advice from me. You've got plenty of vision now in terms of how the law operates. No, we didn't go into the great depths of the law, but that wasn't what this was intended to do. This was one businessman talking to another businessman, trying to make you smart about some of the things to be aware of. So now I want to turn the page and start thinking about invoices. And you might think, well, that's simple enough. I send an invoice to my buyer and everything's good to go, right? Well, let's go back. The governing law is, again, the Uniform Commercial Code, very specifically. And like purchase orders, did you know that invoices, that when they're properly constructed, and we're going to cover that, they too attain the level of chattel. There's a special legal status that they attain when they're properly issued. So what's the deal? How do we make it a properly issued invoice? Did you know that an invoice, to be effective, to be enforceable, can only be written after the completion of your activities on that invoice? In other words, you can't bill in advance and expect that that has any legal standing. It has no legal standing. The only legal standing an invoice can have is if you have already performed on your delivery of those goods or services. But do know that, like purchase orders, a properly executed and issued invoice is enforceable upon that purchaser, and courts will enforce it if it ever comes to that. Also, let's understand the rights of the different parties. You have a right to expect payment if you perform on the underlying invoice, if you perform on its issuance, and if you properly issue it. The payor, the obligor under an invoice, also has certain rights. If, for example, there's a trade dispute that arises, that invoice is put on hold. It is not enforceable if there's a valid trade dispute arising. So don't think that it's just a one-way ticket. The receiver, the obligor under the invoice, they too have certain rights to disclaim or dispute the invoice itself. If you think that you're going to have a late payment provision, if, for example, your invoice is most custom, the invoice requires 30-day terms. In the industry parlance, that's referred to as net 30, meaning that all payments after any deductions or anything else, whatever is due at a net is due in 30 days. But let's say the customer doesn't pay you in 30 days, and you want to charge a late payment provision. Do you know you have no right to do so unless the invoice clearly states what those late payment provisos are? Did you realize that there's no claim whatsoever that you can make for late payment? So if your invoice is deficient, if it doesn't reference anything about late payments, and your customer doesn't pay you for 90 days or 120 days, all you can do is sit on your hands and wait, or take them to court and hope that the court will cause them to pay, but they will only need to pay the invoice amount. There'll be no late payment proviso. So to be enforceable, you've heard me use that term a few times now. Here's the rules. These are the things that must be in your invoice. It's kind of scary, but there's a lot of bullets here. Let's quickly go through them. First off, the party who owes the money, we call them the obligor. They have to be clearly identified. So somewhere on your invoice, it needs to clearly state the name of your company. And it can't simply say Ken's Excellent Company. If the legal name of my company is Ken's Excellent Company, Inc., it needs to say Ken's Excellent Company, Inc. on the invoice. So if you've got an underlying purchase order, you need to look to see specifically who the obligor is under that purchase order and be sure that it is to the T, to the comma, to the I, and to everything else needs to be dotted. Be sure it is exactly the same. It needs to reference the goods or service that are being invoiced. It has to be clear as to what you are invoicing for. And if there's a purchase order, it needs to reference the underlying purchase order, not just to say, hey, Ken, you issued a purchase order, but rather to say, hey, Ken, you issued purchase order number 123 ABC. It needs to reference that because that purchase order and the terms and conditions that you already agreed to will govern much of this invoice. Be consistent as a result with the underlying purchase order. If the underlying purchase order says payment terms are net 60, the invoice needs to reflect net 60. When you signed and accepted that purchase order, you signed and accepted the fact that they won't pay you for 60 days. Was that okay with you? Well, when you signed, you said it was. So your invoice needs to stay the same. If the purchase order says that, hey, we can pay you quickly for a discount. Maybe if we pay you within 10 days, we can take a 2% discount. Well, your invoice needs to say the same. So be sure as well that when you clarify the obligor up on bullet number 1, that you are invoicing the proper place of business. You're not sending an invoice to each of the distribution centers where the delivery went because they won't know what to do with it. They're going to throw it in the garbage or throw it in somebody's desk drawer and not forward it because they don't know who to forward it to. The purchase order will clarify who should be billed. The purchase order will clarify where the place of business is for that invoice to be sent. Follow it to the letter. Your invoice needs to reference a clear due date. Believe it or not, if it doesn't reference a due date for payment, the obligor is under no obligation to make payment by any particular day. They can pick and choose when they feel like paying. If you're going to provide them that early payment discount, be sure it clarifies that. It also needs to clearly state where their payment is to be remitted, your specific legal address, and the specific legal name of you as the seller. Now, you might choose to accept payment digitally, electronically, or require payment in paper to your mailbox. Whatever it is, it needs to clarify the invoice, what that's all about. Did you know that if your invoice doesn't have a unique identifier or a number on it, that it is not enforceable? Guess what? People have learned that the hard way. Be sure that your invoice has a reference number on it. And as we covered earlier, if you expect to be able to impose a late payment penalty, it needs to reference that on the invoice itself. So we've covered a lot about invoices. We've covered a lot about purchase orders, and I'm sure that we've covered somewhere along the way some things that you were not aware of. Let's keep going. Let's now talk about collateral. I've used that term a few times now, and I want to clarify, as this page talks about, why do we care? Well, we care, again, because collateral is governed by that famous UCC, and specifically Article 9 for secured transactions. When I say secured transactions, that means that there's security involved. You see, purchase orders and invoices are assets of your company. They can be pledged or assigned to secured parties to obtain funding. So let's understand two things. If you have already secured funding for your company through a bank loan, quite likely you've had to securitize that loan with collateral. If you have done so, the purchase orders and invoices that you are now creating are likely part of that collateral pledge that you made previously. You might be thinking, oh, no, Ken, when I got that $50,000 loan from the bank a couple of years ago, that was just for the collateral I had then. I would encourage you to reread your loan agreement, because quite likely somewhere in your loan agreement, there's language that says the following: borrower hereby pledges to secured party a first security interest in all of borrower's present and hereafter acquired assets. As you read that, there might be a lump in your throat, because I suspect I've got your attention now. What I've just shown you is referred to as a blanket lien. Unless you knew to negotiate this with your bank when you got that loan, you probably signed away on the loan agreement because it would have been standard policy at the bank. And I'm not suggesting the bank's doing anything underhanded. As Standard policy on the loan that the bank gets a first security interest in all of your assets, both now and hereafter acquired. The bank is going to get that blanket lien unless you know to do otherwise. We'll talk about that a little further. But to those of you that don't yet have a bank loan, that might in the future want to have a bank loan, you are now forewarned. Please know that these purchase orders and invoices are assets of your company. They can be pledged or not pledged to an individual company or to a couple of different businesses. So let's dig into this a little more. Let's understand first what collateral is. Under the UCC code, there are two types of collateral. The first is real property, meaning real estate. We're going to put that off to the side. That's really not going to be a part of this conversation because very few of you have company-owned real estate that you would pledge as an asset to a lender. And even if you did, it would be secured outside of the UCC code in using different forms of collateralization. More likely, you're going to have other types of assets in your business. The unfortunate reality is that the UCC code refers to it as personal property. I need to clarify for you that this is not your personal stuff. All right, please understand that this is the company's personal property, if you can think of it this way. Or better yet, just think of it as everything else in the company. What might that everything else be? Well, that could be equipment, it could be your inventory, certainly your accounts receivable, which are the invoices that you've created. It might be furniture, fixtures, leasehold improvements, or general intangibles. What falls under general intangibles? Those purchase orders fall under general intangibles. So too do a patent or a trademark or name recognition or copyrights or anything of that nature that doesn't fall into one of those other easy buckets. When you provide a bank a blanket lien, you have provided a bank an interest in all of these assets for as long as that loan is outstanding. Let's think about that for a moment. As your loan continues to be repaid over time, as it amortizes down because you performed on your loan, what happens to the principal in that loan? It gets smaller and smaller. During this period of time, your business is continuing to grow. What's happening to the collateral value of all of these assets in your business? They're growing. This is a pretty nice deal for a bank. Their exposure goes down and their collateral value goes up. As a consequence, blanket liens are things for you to avoid. If you know to negotiate this ahead of time prior to securing that loan, you can provide yourself a great deal of flexibility to work with additional incremental lenders beyond just that bank. Why is that important? Because I can't assure you that your bank is always going to say yes to you every time you need money. You already got that $50,000 loan and you turn to the bank and you say, hey, I just got this big purchase order for another 20,000 units. I can't perform on this. I don't have this in inventory. I need an additional $100,000 so that I can perform on this, but it's going to give me a great new customer in Walmart. How am I going to work? And you listen to the bank and they hem and they haw, and eventually they'll never say no. They'll simply say, well, we're comfortable where we are right now. What that phrase means is, no, we're not going to give you additional money. So now you're in a bind. You can't find additional funding from any other institutional investor because, or I should say institutional lender, because all of your collateral has been pledged to support that small initial loan. You've got no cards to play, ladies and gentlemen. As a consequence, I urge you to keep some of these cards to play for a rainy day. In the future, when and if the circumstance arises that you need an incremental lender, you don't want to be tied at the hip to the one lender who is saying no to you. You want to have free and clear specific types of collateral to work with. The easiest one for your initial lender to give up on is accounts receivable. The reality is that because the lender doesn't know who you're selling to and has low chance of collection on those accounts receivable, they know that recovery of anywhere north of 25% on accounts receivable would be a good day. So they know if they had to move against collateral, they know that they're not going to get much in the way of accounts receivable remitted to them. So of these different categories, they look at that one as least important to them. So too for general intangibles. So you might say to your lender, should you have a future one, hey lender, I understand you need collateral. I'm prepared to give you collateral. I'll work with you on equipment and inventory and furniture and fixtures and improvements, but I need to leave outside of your collateral lien interest certain of these assets so that I know if there's ever a day that you can't say yes, when you can't say yes, that I have a card to play with an incremental alternative lender. I need to leave accounts receivable and general intangibles alone. If that's the case, most of the time your lender will initially say no, unless you say to them, no, I really need to have this. They will likely blink because they understand what's going on. I say all this to you guys, understanding that there's additional cards for you to play to incent them to work this out. Please remember that all of us as small and mid-sized business people will need to personally guarantee obligations. That's not on this screen. That's an additional card that you can play with your lender, your prospective lender, to say, hey, I can personally guarantee it. And hopefully that personal guarantee has certain value to it, that you have some net worth that's attractive to a lender and influential to that lender. Do know that it's virtually unheard of for you to avoid that personal guarantee. So please know that you're going to have to personally guarantee whatever kind of loans coming at you. Understand that. Understand that's the rules of the game. Understand that's the lay of the land. Heck, even as my business grew, we were doing 50 million a year in revenues. I still had to personally guarantee a $10 million bank line. Unless your company goes public, it's really kind of unheard of for you to be able to extract your way away from a personal guarantee. So that's an additional card for you to play to incent the bank to not take that blanket lien that I think I've educated you enough about to know you really want to avoid that blanket lien. So know this, know that collateral pledges are negotiable. Don't get fooled into providing a blanket lien unknowingly. Keep certain of your assets free and clear from that collateral pledge so that you can work with a purchase order funder. What's that, you might wonder? We'll talk about that in a different tutorial entitled So the Bank Said No, Now What? And in there, we'll also talk about factoring. We'll talk about asset-based lending. These are things you may not know much about or may have heard a little bit about and would like to know more. That's where your savvy in managing your collateral will come into play to enable you to work with additional types of financiers so that you don't have to simply pass the hat to find some investor and give away pieces of your business. So ladies and gentlemen, we've covered a lot here. We've covered a lot of legal stuff. We've covered a lot of things that are critical for you as a practitioner in this space of selling goods and services. And I hope we've covered enough to make you successful in your endeavors by selling your goods or services to big box retailers. I wish you all the very best. Good luck.